Welcome to the deep dive. We're your shortcut to getting up to speed. Today, we're digging into a recent Supreme Court ruling out of India. It clarifies, a pretty significant shift in criminal procedure.
That's right. We're basically looking at the change from the old Criminal Procedure Code, the CrPC, to the new BNSS, the Bharatiya Nagarik Suraksha Sanhita, specifically around how FIRs, first information reports, get registered.
Right, and also when the police can actually do a preliminary inquiry before registering that FIR.
Exactly. And it's a fundamental change, really. Could be a crucial filter, sort of, to stop people getting tangled up in the legal system unnecessarily right at the start.
It really sounds like a major departure from the old way. So let's, break down what's different and why this actually matters for you, the listener. Where should we start? Maybe the baseline, like when does an FIR have to be filed? No questions asked. Okay, so both the old law, Section 154 CrPC, and the new one, Section 173.1 BNSS, they have this core principle, right? If the information given clearly shows a cognizable offense, that's a serious crime, police can arrest without a warrant, then registering that FIR is, mandatory.
Absolutely mandatory. The information needs to be written down, read back to the person who gave it, signed, recorded properly, standard stuff.
So no wiggle room there.
Typically, no. If a cognizable offense is clearly disclosed on the face of it, the police officer doesn't really have the option to start poking around first. The FIR gets registered. That's been the general rule.
Okay. But now, the new law, the BNSS, brings in Section 1733. And this is the game changer, you're saying?
This is where things get really interesting, yes.
Yeah.
Subsection 3 creates a specific exception to that mandatory rule in subsection 1. It gives a police officer the power, though. Importantly, they need prior permission from a senior officer, at least a DSP.
A deputy superintendent of police, right? So there's a check.
Exactly. With that permission, they can conduct a preliminary inquiry. And here's the kicker. They can do this even if the information they received seems to clearly disclose a cognizable offense.
Wow, okay. So even if it looks like a crime happened, they can pause and investigate before the FIR.
Under certain conditions, yes.
And what are those conditions? Is this for any crime?
No, it's specific. This power for a preliminary inquiry applies only when the alleged offense is punishable with imprisonment for 3 years or more, but less than 7 years.
3 to 7 years, basically. Not for the most minor things, not for the most severe, but that middle band.
That's the range. And we actually saw the Supreme Court apply this quite recently. They quashed an FIR against an MP for an Instagram post, specifically because it fell into this punishment bracket, and argued this preliminary inquiry step should have been considered.
An Instagram post, yeah, that brings it home how relevant this could be. So under the old CrPC Section 154, and thinking about that Lalita Kumari case.
Right, the landmark case.
Yeah, under that framework, this kind of preliminary check wasn't really allowed if the offense seemed clear, was it?
Generally, no. Lalita Kumari said if a cognizable offense is disclosed, register the FIR. A preliminary inquiry was mostly for cases where it wasn't initially clear if a cognizable offense had even occurred.
So the purpose of this new Section 173.3 in the BNSS is different then?
It seems to be, yes. The goal appears to be to check if there's actually a prima facie case, enough credible basis to proceed before officially registering the FIR, specifically for these 3 to 7 year offenses. It's aimed at, filtering out potentially frivolous or weak cases early on.
Okay, that makes sense. But I'm wondering about the very first step. Before even thinking about a preliminary inquiry, doesn't the officer have to figure out if the complaint describes a crime at all? Like just reading the words, is that considered this new inquiry?
That's a really important distinction to make. You're right. Take an offense like, say, Section 196 of the new BNS, the Bharatiya Nagarik Sanhita, deals with certain kinds of speech, punishable up to 3 years. For something like that, the officer has to read or hear the words involved to even decide if they might constitute that offense. They need to assess the content.
Right, you have to understand what was said or written.
Exactly. But that initial act of just reading or listening to understand the complaint and see if it even alleges facts amounting to a cognizable offense. That's not the new preliminary inquiry under Section 173.
I see. So understanding the basic complaint is just part of the initial assessment under 173, the mandatory part.
Precisely. It's the step you take to decide if 173 applies. The new preliminary inquiry under 173.3 is an additional discretionary step for specific offenses, happening after you've already determined that, yes, the complaint does describe a cognizable offense within that 3 to 7 year range.
Okay, got it. So, wrapping this up, what's the big picture takeaway for you, our listener? This shift really changes the initial steps police can take. It gives them more discretion at the start.
It does, and with that discretion comes a significant responsibility. The Supreme Court actually issued a warning about this.
Oh, what was the warning?
They cautioned that if police don't properly use this discretion, this ability to conduct a preliminary inquiry under 173 when appropriate, well, there's a risk that FIRs could end up being registered against people who are just, exercising their basic right to freedom of speech and expression under Article 19.1.
So, it's a tool meant to protect the innocent, but if misused or not used, it could inadvertently harm free speech.
That's the potential tightrope. It really highlights the delicate balance this new law tries to achieve, balancing the need for effective investigation with protecting fundamental rights. Something important to keep an eye on as this unfolds.